Okay, so we'll call the meeting back to order. We just had an interesting session with
That's great.
Gus and BHCB people. Yeah, very interesting. Sounds like they're humming. And so anyways, we wanted to invite you folks over. We've got that right to farm bill, and I'm sure you've looked at it, read through it, and we need I guess hear more about if a farm meets the RAPs. Is that and what that covers, and if I guess if you feel if a farmer is following, he's been there more than a year before the neighbor comes, and he's following the RAPs, if that's an adequate measurement to show that the farmer is farming within accepted ag practices, is that enough to protect the neighbor, so that if the farmer is really doing something bad, it would still give the neighbor some protection to clean that farmer up or straighten them out? Or are there other things that we should maybe add to the bill that would ensure that? And so we're still in the process of putting the bill together, and want to get it as close to being right as we can. So you both sit at the table if you'd like, or one at a time. Morning.
Morning. Good morning. Would you like us to start, or?
Yes.
Okay. Steve Collier, thank you so much for having us from the Agency of Agriculture. And
Laura DePietro, Agency of Agriculture.
Yes.
I think so. Maybe we could start by, I'll take the legal question a little bit, and then maybe Laura can explain because Laura is the Director of Water Quality, and
Yes.
she's the most knowledgeable person in our agency about what the RAPs do and what they regulate. And then I personally think it's a fascinating policy question. I've been thinking about this quite a bit because it came up last year and it came up again this year. And when you think about nuisance law, it evolved from the common law, which means from England, from, it's centuries old, and it does some really important things. But it also comes from a time when you could pretty much do whatever you wanted on your land, unless you interfered with somebody else's land and their use of that land. So it balances important principles, but it also stems from a time when land use was not regulated or not heavily regulated. I would argue that we've morphed quite a lot over time into how we allow people to use their own land. And a lot of those are for very important reasons, to balance both the private landowners' uses with public and societal needs. But there is a very big difference between being able to do whatever you want with your land, as long as you don't interfere with somebody else's use, and already being regulated for what you can do. And right now, there are quite a labyrinth of regulations that apply to farms, both for, and primarily in the RAPs. Most of that is designed to address water quality and to ensure that farmers aren't polluting all of our water and resources, which is very important, obviously, but it's quite different than when you could do what you wanted on your farm without really too much regard of what happens with what you do. So I think the right to farm law was first enacted in Vermont in 1981. That was before there was any regulation that I'm aware of on farmers' use of their land. over the last, 40 actually, 40 years, the regulations have consistently increased. And so now there are standards, and those standards have been set by you, by the legislature, and by the administration through adopting the rules that you've given us the power to do. So I guess the policy question from my perspective is, who should be deciding what farmers can do without being subject to additional liability for their actions? And so right now in law, farms have to conform with all laws, not just the RAPs, but all laws, as an element to get this rebuttable presumption that we talked about before. So if you're not complying with laws, then you're not entitled to that rebuttable presumption. My concern with the current statute is really from the legal perspective. Like when you try to give someone advice, legal advice, regardless of whether you're representing a farmer or you're representing a neighbor, you try to analyze the law and then the facts that you have. What I think is really detrimental about the current law is that it's really hard to give good advice to either the neighbor or the farmer about whether what's happening right now is acceptable, because the scope is so broad that you can really, in almost any case, make an argument that you have a chance. And that's good if you're a plaintiff and you want to be able to do something. It's not so great if you're a business and you want to know what's permissible and what's not permissible. So right now you can be complying with every law and still be, I think, quite subject to a successful litigation. And that doesn't necessarily mean that you lose at trial, but that you go through potentially years of litigation getting to that endpoint. And so certainty, I think, is important for everybody. Mm-hmm. And so what I personally think is most important to happen to the law is that there's some level of certainty so that both neighbors and landowners and farmers know when they're in the clear and when they're not. And there's never going to be perfect certainty. But right now, I feel like there's no certainty at all, or very little. So clarity is really important. I think there's a lot of policy choices that can be made about determining what that clarity should be. But once you have that clarity, then people can make good decisions. And I know it's come up, I've heard it come up quite a few times that, well, what's the problem we're trying to address? Like, how many civil suits are there? And that, that's an important question, but I don't think it's the most important question, because we know that neighbors get into disputes with farms already. We know that from talking to farms. We know that from people calling us. We know that from farmers testifying in here and other places. These disputes exist. But whenever you have that kind of dispute, the question is, how is it going to end? And when you have a clear law and clear guidance, then both parties have more understanding of what's reasonable for them to ask and what's not reasonable for them to ask. Right now, I think it's harder to get a quick agreement because it's not really clear. Farmers, I think, have this understanding that if they're following the RAPs, then they are safe from civil suit. That's not true at all. It'll never be perfectly true. Anybody can sue anyone, regardless of what the law says. But I think a benefit of having a good law, a clear law, is that if it doesn't pass muster, a court can dismiss it quickly. And that's why part of what I think is important is whatever you design to change is that the burden, we believe, should be on the plaintiff to prove it. So right now there's a litany of things that make the rebuttable presumption go away. But I think the way the statute is set up, there's a good argument that the farmer has to prove they met those things. That's not the way a civil suit is supposed to work. The civil suit is supposed to be, if somebody is suing you and claiming you did something wrong, they have to prove that you did something wrong, and they have to prove that whatever you're doing wrong has harmed them. I think that's a fundamental tenet of our legal system. So why not make it clearer that whatever protection you put in place for the farm, make it clear that the plaintiff has to prove the farm isn't meeting those standards.
Well, isn't that, it's almost the law of the land, isn't it? If you get stopped for speeding, the officer or whoever stops you, they have to prove that you were speeding. The plaintiff,
state in that case.
Yeah, the state would have to prove it, but owning 35 tractor trailers, I have been to court a few times.
Yeah.
And it seems like you almost have to prove your innocence these days to get out of litigation. I mean, the law doesn't, the courthouse doesn't work like we all think it's supposed to work, that whoever brings the plaintiff has to prove that you did them wrong. I mean, I found that, you know, you go in there and you want to have a damn good lawyer with you to prove that you weren't doing something wrong, more than the plaintiff comes in and presents their case, and it seems almost always that you have to defend your own ground.
Well, I think you're absolutely right, Senator, that once you're in litigation, it is very challenging for both parties, or all the parties that are in litigation, and each party wants to be able to prove it's right. No question about that. But from a pure legal perspective, the court can't decide facts, and an environmental court can, because they don't have a right to a jury trial in some of those instances. But generally speaking, where you have a right to a jury trial, it's only the jury that can decide facts. So if a court can't, if two people are saying this manure, one person saying this manure stinks and the other person saying it doesn't, a judge can't decide that. A jury has to decide that, if it's something where a jury has the right, whether somebody has a right to a jury trial. What a court can do, though, as a legal matter before you get to trial, is decide whether the plaintiff has even stated a colorable claim. And that's where this burden of proof becomes really important, because if the plaintiff can't prove a case, then the court can dismiss it. If they don't have facts to show that a farmer is violating the REPs, for example, if they don't have facts to show that the farm's violation of the REPs is causing the nuisance, then a court can look at that and say, look, even if I believe everything you say, that's not adequate for me for you to proceed on this case. So that's why the burden, I think, is important. And I think the way the law is written now, and I don't know that any court has interpreted this, and Judge Teachout's opinion with the recent case with Button Bay and what happened at Worsted Farm, she interpreted it as an affirmative defense. She didn't specifically say that in her order, but she said that the farm didn't prove X, the farm didn't prove B. And that's, I think, because of the way the statute is written, it suggests that for a farm to be entitled to that presumption, the farm has to prove all these things. And for a farm to prove that it's complied with all laws, that's just too broad a scope. First of all, it shouldn't even matter whether you complied with, you know, a motor vehicle regulation for your muffler if the case is about whether or not your manure stinks. So there's a way, I think, that can be narrowed, which is in everyone's interest. It's in the neighbor's interest to know what because that's very expensive to bring a claim, and you don't want to bring a claim and lose it if you're a plaintiff, especially if you don't have money to lose. So that clarity, I think, would go a long way in enabling both farmers and neighbors to know what's permissible and what's not. And it would facilitate better negotiation at an earlier stage. If a farmer is violating some rule that you've imposed, we're going to be telling them they have to fix it. And the neighbor can be telling them they have to fix it. And hopefully they'll understand they actually have to fix it, or there's going to be some repercussions for them. Whereas if they're doing everything right from our perspective, but then a neighbor doesn't like it, that puts them in a very different position. And I think the question from a public policy perspective is, who gets to decide what sort of farming is appropriate? Is it, yeah, sorry.
It is just a comment. It sounds like the uncertainty to me benefits the lawyer.
It often does.
Brian?
So what I'm trying to figure out is we give the agency of ag, which people I think publicly know I disagree with, water qualities oversight in some regard. And then we heard last time we were in here that only 70% of our farmers were in compliance. And it just strikes me as more of a, I mean, we wouldn't call, and this is me sort of thinking this through, if somebody was complaining about pollution, we don't call the car industry to sort of monitor pollution, or the oil industry to monitor pollution. And this just seems to me in part like we're giving so much more say to the Agency of Ag, when we know, and I don't know where the EPA is in all this, that there have been major complaints about the Agency of Agriculture as it relates to major concerns, I would say. ANR and Agency of Ag have been in disagreement over who should have, the right over water quality. I know that there's something before the EPA. I don't know the details, that they're trying to settle something around this for us. You guys may all be able to speak to it. But I just don't feel confident saying to people, hey, the folks that are overseeing farms and farm expansion are in charge of water quality. I mean, they're going to be the first ones who are going to come up and be witnesses before a court, I feel. Hey, who are we going to hear from? We're going to hear from the people that are in charge of overseeing it. And there's something that I just doesn't feel right to me in all of this. Maybe you guys can wait. And I know we're going to hear from other people. I don't want to just hear from Ag. I've been clear with the chair on this. I don't think, and I do think, my colleagues in judiciary, I know are going to look at this also, but there's something here that just does not feel good to me. And I don't know if you guys want to weigh in on this or.
Yeah.
I mean, it's just my own sort of.
Yeah, no, I'll just say that,
Yeah.
I worked here for 19 years and
Yeah.
I take my job really seriously. I'm not the most loved person in the agency from that perspective of the ag community.
Yeah.
And the reason that 70% is there is because we're doing our job, right? And so in reporting it out to you and trying to be as transparent as possible.
Yeah.
And over the 19 years, there have been a lot of, this Fox watching the hen house conversation, as you know, has gone
Yeah.
on
Long time.
well before my tenure there. And it's never been founded to have anything but, there's never been negative stuff that's come out of it, right? It hasn't ever gone the other way. And I think if you look through all of our records, which they're all available publicly out there, you will see our staff are out there doing their job, and we do it in pairs so that there isn't a bias, and we rotate them around and we publicly share everything that's out there. So judge as you wish, but look, right?
Yeah.
I really
No, I'm
strongly
I'm going through all these documents now that were handed to me, and it seems like there's a disagreement between the Agency of Natural Resources and the Agency of Agriculture around who should. Okay, I mean, maybe I'm misreading these emails. Okay.
If, may I just jump in? So we are the state of Vermont.
Yeah.
The executive branch. The Agency of Agriculture is part of the executive branch. The Agency of Natural Resources is part of the executive branch.
Yeah.
There's not any component of that in my opinion, that equates us to the industry, overlooking the industry. We're not saying that farmers should get to decide to do whatever they want to do.
Mm-hmm.
We're saying that the law should decide whatever farmers are allowed to do. And we are one of the entities that enforce that law. There's a lot of discretion in enforcement. A trooper pulls you over for speeding. Some people say, "Oh, see you next time, Senator." Some people bring you in. And I think where some of the disagreements have arisen over time is how harshly to penalize someone for violations. There's a lot of room for criticism. There's also a lot of effort on our part to be consistent. So, we are really, you can say that anytime anybody violates any law, they should have a maximum penalty. We can give somebody a $5,000 penalty for one offense, up to 50,000 total. Maybe we should, some people would say, you know what, every time you should give them the maximum penalty.
Right.
That's not our approach, because we're not trying to exact money from people. We're trying to get compliance. And I think through Laura's team, what she has done is she's built trust with the people that we enforce against, which is not an easy thing to do, which does not mean they're always happy with us, because they're often not happy with us.
Right.
But when you try to be fair, we try to be balanced, we're not trying to, farmers don't have a lot of extra money. We're not trying to get the biggest dollar amount we can every time they do something wrong. If they continue to do things that are incorrect after we point it out to them, that's when the penalty gets higher. We believe that's an appropriate method of enforcement. I think people at ANR feel the same way, and we do work very closely with ANR. We talk with them about a lot of things. They have an important role on farms already. We have a corollary, also important role. The petition that you talked about was filed by environmental groups who believe that ANR would enforce more strongly against farms and probably would drive some of those farms out of business. So that's a policy choice. Right now, we have that authority. We think that we do it really well, not perfectly, because you can't enforce and do anything perfectly. You could evaluate any decision and criticize it, but I'm very comfortable with the work that we do and the work that Laura does, and believe that trying to get people to cooperate with us is a better way to go. Because if you just hit somebody over the head every time we show up, they stop being honest with you, they stop cooperating with you, they view you as the enemy instead of somebody to help. And we want to educate people into compliance. And when you look at the phosphorus reduction, the proven phosphorus reduction in the state, 95% of it goes to ag. That's a fact that no one seems to want to talk about.
Yeah.
No, and I appreciate it. I really do. I just want to I want to make sure that we've got to go out and talk to our colleagues. I want to hear, there is another side to the story. And that's all I'm asking, really.
Which side do you?
Well, I want to hear, I think it's important to hear from those that don't like, that are concerned. There are attorneys out there who are concerned. There are environmental groups that are concerned. I mean, we can't, even if it makes it to the floor, we're going to get these questions. People are going to ask us, hey, did you hear from so-and-so? Did you hear from so? I mean, these are worth, for me, in any committee, you've got to hear from both sides of the story.
Well, yeah, but to hear from both sides without one side telling you facts, the other side exaggerating the situation.
Well, be careful. I mean, that's your opinion. We can all,
I think it's pretty inaccurate. I'm not exaggerating how they exaggerate, I'll tell you. And, I'd like to know, if you want to get into it good and deep.
Yeah.
How much phosphorus has ANR removed from the lake from industrial sites? And
let's have them in. That's all. That's my point.
if you want to get really.
Yeah, I'd love to have them in. Sure. Absolutely.
But it's a known fact that ag has extracted the maximum or the most amounts of phosphorus from our waterways, way more than any other single industry.
Listen, all I want to do is make sure that what comes out of this committee, we've heard from everybody. I understand both sides. I want to understand both sides. I mean, it's not like you're proposing this is the end of witnesses anyhow. I just think it's important for us to be able to talk to our constituents, have this conversation openly. So that's all really I think I'm asking for, is there's got to be, to every bill, there's some opposition, right?
No.
Of course.
I've seen bills this school lunch bill, universal meals, there was a 29-1 vote. Well,
There's always going to be a little opposition.
That's
Just want to hear
pretty
it, right?
much unanimous.
Right. That's fair. Yeah. But we also did hear from both sides. At least in my committee, we had people come in to say, hey, let's just have the wealthy families pay and the low income families are taken care of. They weren't convinced that there was a missing middle. And we learned that during testimony.
Just so you know, Senator Camping and Senator Starr actually asked me if ANR would like to participate in this hearing, and I reached out to ANR and they said they didn't feel like they had a voice in this particular issue. So we look, the disagreements with ANR that are out there.
Yeah.
There have been real disagreements. I don't have a problem with that. I think that actually makes policy better when you're looking at both sides and when you're addressing it. But we work with ANR and they support, as far as they tell us, the continued split that we have in this authority. And we do coordinate with them and we share our information with them, as we should. We're all part of the same state.
Right.
So anyway.
And you've seen this document also that was forwarded to me.
I don't know what you're looking at.
All right.
Then
Maybe we'll get everybody a copy. This March 16, 2022.
Who'd you get it from?
This guy who's coming in, you said, what's his name? Steve Sussman. From CLF?
Oh, wow. I could probably tell you what's in there without even looking at it. If you really want to know.
What's the name? Scott Sanderson. Thank you.
So anyways, so Laura, are there other measurements that we could use that would strengthen the bill? Is there some other requirements that where 90% of the farmers meet the requirements, or because we're interested in water pollution, waste pollution, abuse to neighbors, that there is such a thing. Is there some other measurement that or thing that you regulate on a farm that would help to protect the neighbor in a greater way?
Well, if I were to just structurally look at what the whole conversation is about and trying also to address some of Senator Campion's concerns, fundamentally, if you're going to have right farm, you have to have some standards, right? There has to be something that the farm needs to comply with. There are currently standards on the books. Whoever implements those is a different conversation, right? Right now, we have REPs, MFO, and LFO in the Agency of Ag. There's CAFO at A&R. So for water quality, if that's the focus you want to be at, those are the water quality regulations that are predominantly dealing with agricultural pollution, whether non-point source or point source, right? And farms have to comply with all of them. It's not optional. And so, again, I think a separate conversation is the desire of who is doing what, but if you need a standard and you need to apply that standard to farms to see if they meet the test and if they're compliant and practicing those standards appropriately, that they would be considered not to be having a nuisance from those activities. I think that that covers the areas of ag water quality pollution at this point. And it gets both agencies as well, right? Because they have to comply. There is no option not to comply.
And is a 70% number, is that a real number, or is that something that somebody made up?
Well, let me just remind you, we regulate non-point source pollution. So those are not, let's call it 70% compliance, so 30% non-compliance.
But is it a made-up number? That was the question.
Oh,
Okay, right. No, that was the question.
Oh,
That was
but
what
it-
the chair just asked.
so but I'm describing that 30% is not actually waste getting into water. We regulate it before it gets to water, right? So our job is to prevent it from getting to water to start with. Once it gets to water, it goes to A&R, and that's their regulation, right? So if you can ask them of what we've given them, what they've found as a percentage of a violation, because we give them more than everything, right? Like we have to be a little more conservative to give them things because they decide what is a discharge versus not. So if we think it could be a discharge, we have to send it. But so the 30% non-compliance is stuff that's a risk, the stuff that's not an actual, right? Or preventative. But no, it's data, the wazoo, and it's, as you saw what we're able to do, it's all an open book. You can look at it all. And, there's thousands and thousands and thousands of emails.
So are you saying that 70% meet everything? 30%, they could be lacking one or two things, and that's why they are not in the 70%?
Yeah, like a simple example is, so if you have a bunk and or we've done it or someone's done it on their own, there's a system to collect the leachate, right? If for some reason, as they're cleaning that out, there's spillage over the back edge, and on the other side of the state house, there's a ditch, we would say, that's not how you're supposed to manage that. You need to keep all of that inside the bounds, because that's what the bounds were created for. Because there's a risk that, if Noah's Ark and all the things come together, that there could be a discharge. We wouldn't want you to be in that situation. Therefore, preventative violation, please do better housekeeping, right?
So that particular example would make that farm not in compliance, but all the other things are in compliance, but there's that one thing that it's holding them from being in the 70% or 71%.
Yeah, farms often have 15 to say 40 assets is what we call them. So individual pieces of infrastructure in a production area that we would look at. if one of them is not compliant. And it could, again, not be, it could not be anything to do with water, because sometimes we also regulate things like siting and zoning and other things, right? But it would knock the whole production area out of compliance. So like that, the 95% plus reductions that we've been talking about for TMDL, that whole production area is not counted for that one thing. So we've got a lot of detail and assessment, and DEC, us and our accounting and tracking stuff that we do, we run it all through them, and they QA/QC everything. We have a committee that they're part of to develop all these standards. I think we've done what's been asked of us.
But if somebody in downtown Montpelier reads what Brian just read, they would think that 30% of all the farms in Vermont are non-compliant. But there could be of that, in that 30%, if that meant 100 farms, there could be one thing wrong on each one of those 100 that would bump that percentage to 30. So it's like I said when I started, some people read things a lot different or see things a lot different and exaggerate their statements on.
But I read that
limited
from, I read
information.
that from the presentation that she gave.
The
Yes,
30%.
yes, that's where I took it from, that's all.
Well,
That's the number that I was talking about, yeah.
but there is 30%.
Right, no, that's, I know,
Could
right.
be one item on a farm that's retaining them or keeping them from being in the positive zone. I think I'm saying it right.
Well, and if I may just add something, the whole idea of the required agricultural practices is to set up preventative measures.
Yeah.
So the farms are doing things appropriately to prevent discharges. So I think to Laura's point, there may well be violations that have absolutely no impact on the environment, but they have a potential to have an impact on the environment, which is why the rules are there.
Right.
So 30% could mean maybe 5% of those 30% actually had violations that were damaging, or maybe it's more than that. But that number in and of itself doesn't tell very much of the story. If you have you have to have a 25-foot vegetative buffer downstream between surface water and field.
Right.
If that buffer is 20 feet instead of 25 feet, that's a violation of a
Right.
rule. That doesn't mean it's had any impact whatsoever, but the rule is you need a 25-foot buffer, so the farmer has to have a 25-foot buffer. So it's a very different question to analyze the damage from those violations than it is to analyze the number of violations. You know, probably most drivers go through a stop sign sometimes when no one's
Sure.
around.
Sure.
Shouldn't be doing it. It's a violation of the law, but there's no impact to it. And so that's an important assessment of when you're looking at stats is what's the actual impact? And when there is an impact, how do we address that impact? And I think what we're looking at is, okay, we look at violations, technical violations,
Yeah,
but we also want to look at what does that mean
yeah.
in terms of the potential or actual harm it's caused.
So what happened with this big case, this Voorheesville case? Is it Voorheesville?
Force development
Voorheesville.
farm.
So what happened there?
Well, it was a nuisance action that went to court in Addison County, and it went to trial. It's on appeal right now before
Okay.
the Supreme Court. But a neighbor who has a home on the lake sued the farm
Yeah,
and over their smell and over their
just
water
the smell.
quality.
Okay,
No,
okay.
and also over what they feel are discharges that are impacting their property from tile drain that's on the farm.
Okay,
And so that was a trial before Judge Teachout in
Okay.
Madison County. It was about a year and a half ago. Earlier this year, sorry. And maybe March or April or so.
so they were in violation.
That's what the court, no,
No.
So if I could give a little
Yeah, I'd
history,
love that.
because I had been on inspections on that farm prior to them owning it.
Yeah.
With EPA, actually, because EPA comes and does spot checks, right, of how we're all doing. And at the time, the previous owner, there's a stream that runs nearby the production area. And the previous process was it has like a drop down, right? So the farm is up here and there's a drive.
Yeah.
And you would park a wagon down there and push the manure over. The stream was right here.
Yeah.
And so we all looked at that and there was nothing getting into the water. We were, no. this isn't good, right?
Yeah.
And so that pursued, EPA and DEC would deal with that from those inspections, but new farmer comes in.
Yeah.
And we said, look, this was already in a situation that was already being in the process of being addressed. Sale has happened. You still need to address that. And, my understanding is when they bought it, and this is, I don't have facts on this, but, they reached out to us
Yeah.
to address that. Our engineer works with them. They've done a number of projects. So they're very comfortable calling and asking for support. They put in the infrastructure that needed to happen. They put in a manure
The
pit.
new folks.
Yep.
Yeah.
We supported it. And so, and it's a moderately sized farm. It's not a huge, it's a satellite site. It's not what you would think of as a traditional large farm if you look at it isolated by itself. But that practice needed to happen. We were all requiring it to be happen. New owner put it in.
Yeah.
And so, and the actual storage, right? A couple of years later, now we're looking at it. We've not had any compliance issues with the management of the storage that was installed.
Okay. So can you just take the next step so I can understand what happened a little bit more? So there was a complaint, but there was no violation. There was no really, in your opinion, no
There was no water quality violation. The complaint was about the nuisance of the smell.
of the smell. Okay.
Which when, an agitation of a manure pit, you have to agitate it
Yeah,
to keep it,
to keep it going.
Yes.
Yeah.
and then land application. And so it's very common on all farms
Yeah.
that they do that. And, yes, it smells for a
Yeah,
couple of days
totally.
while they're doing it.
Completely. Yeah.
And then that's that.
So now it's before the Supreme Court. Okay. What did
That's what I
teach out? What did teach out say?
She found that it was a nuisance and a trespass, both the water. I'm not sure if she found that the smell was a trespass, but she found violations for both the water and the smell.
So the judge found, based on what the testimony she heard, that there was a violation in terms of water quality.
No,
No.
we did not get
Nuisance.
asked questions specifically
Okay.
about that.
Okay.
when
And what
we
does it mean when
testified.
she said a nuisance or a trespass? What does that mean? What did she find?
And
What is that?
trespass is an invasion of someone's exclusive right to use their own property. So she found that the water that was going through some sort of stream bank, I don't know, I haven't seen it myself.
Yeah.
But the water that was going across the property boundaries on the neighbor's land was both a trespass and a nuisance because the volume had increased, was what her finding was.
Okay.
But
There were
Thank
two
you.
separate, so the manure pit was not related to that. There was
Okay.
tile drainage, which was the trespass of water. So
Okay.
water crossing property boundaries, right? So even like my house has a drain, right?
Yeah,
Vermont.
yeah,
Any drain that would cross the property boundaries potentially could fall into that space. So that's what they said, that the water leaving one boundary to another was trespass
okay,
from the tile outlet. The manure, the smell was nuisance.
okay.
So trespass and nuisance.
Thank you.
So the
That's helpful.
trespass,
Thank you.
they put the tile drains weren't there. And they couldn't do a lot of ag work on that field because it was wet, I understood. So they put tile drains in to drain the field. But tile drains, you don't run a pipe all on the end of the drain. You don't hook a pipe, you let the water run in a ditch.
Right,
The ditch goes down through toward water doesn't run uphill, so it had to run downhill. And it ran over onto the neighbor's property. I think that's.
Yeah, it goes into a roadside ditch and the roadside ditch will lead to the lake eventually, right? It's all hydrologically connected. But, and we had done a number of, we got the complaints, we did the investigation, A&R got the complaints, A&R did the investigation. And, according to the REPs, meeting the erosion standards, right? So not having runoff erode the field, having buffer standards, all the things that we're looking at, we didn't find violations of those things. So.
that's helpful.
Yeah.
Thank you.
Irene.
So some of the proposed changes that we talked about, I think at your last visit, might have made this case impossible to bring. Is that what I understand? Or less likely of having this case brought if there weren't those 4 conditions, for example?
Yes, I think so. I think that if a court were to find that somebody was complying with the existing laws, then there shouldn't be a separate nuisance action. As I understand what Mr. Grady's drafted for the committee to find, there's another tenet in there about the not being a nuisance or a trespass. I think at the time the activity was initiated. So, but yeah, I think the idea of having, from my perspective, the idea of having the right to farm protection is that everybody knows what the standards are that are applicable. And if you meet those standards, you don't have a separate action and nuisance.
Yeah, you need the policy that's set out, laid out in law. That's a completely different discussion than the enforcement level, the ANR or the agency of ag would do. So, and you are questioning whether or not what kind of a job the agencies and departments are doing. It's a different question than what the policy is and whether or not you go to court on whether they meet that.
That's an important point on that, but I would say that, and this is something that I think a lot of farmers don't understand. They think that we decide, they think we decide in a nuisance action whether a farm is meeting the standards. That's not true. The court decides. So to your point, Senator Westman, if we weren't doing our jobs correctly, and a neighbor went to court and said, this farm is not meeting the standards.
Yeah.
It would be the court that decides whether or not the farm is meeting the standards, not us. We have authority to bring enforcement actions. We don't have authority to tell a court how to decide whether or not a farm is satisfying the law. We could provide evidence in court, the court could listen to us, but we don't make that decision. So regardless of what we do or what ANR does, if a farm is violating the law and a neighbor can prove it, the court would still have authority to find the nuisance irrespective of what we've done.
And, yeah, we used to, wasn't very long ago, we had 1,000 farms. So that meant you had to inspect 1,000 farms. So now we're down, pushing 500, it's getting toward that. So those farms must be well inspected, because I haven't heard of you folks having a layoff. So there's a lot of inspection that is in place that's ongoing on these farms. And I mean, I would presume that the big guys in medium-sized farms, they must get inspected real every year, don't they? Or the big farms on an annual basis, medium farms, how often? 3 years?
Yeah. Good job.
3. And so when you do inspect the smaller farms, how do they usually do? Of the 70% that are in compliance, or the 30 that's out of compliance, do you know, is it broken down so you know if they're small, medium, or large?
It is, and you can look at that data, but just to give some context to what I see, this is anecdotal from my seat that I sit in. We're watching, like, the land base is still being farmed, right? And if you look at milk production numbers, you see they're still there. So it is an aggregation that is occurring. So what happens is, and because we have to work with farms to address permitting or other things as they go about change, they're buying these smaller farms, right? And so while 15 years ago, an LFO inspection, large farm inspection, on an annual basis might have been, let's go to the 3 sites that have facilities where they house animals. Now, many of them, it's 9 sites, right? Because they bought all these other farms. And of course, they're going to use the manure storage if it's available and meets our standards, and they can use it. What we see often, and we've had a lot of conversations with these large farms, is, remember, we didn't have the staffing capacity, right? Small farms were rarely inspected. Right now, since Act 64 of 2015, we have to do it every 7 years. So there's some, it's just now coming up on we're coming on 7 years at this point this year, but they weren't regularly inspected, right? Because we weren't required. If we got a complaint, we went out, but we weren't. So now a large farm buys a small farm and nothing is in place to meet the current base standards, right? And so they're like, what gives? Like now, they put all those investments in and they do all that work, but they started, if I were to inspect them, I would say you're non-compliant day 1, right? You just made a purchase and now you bought it, but that doesn't mean that they're not bringing it back into place, right? So I don't know, and I haven't looked at the data to figure out. What we do know, I believe, when we looked at it, was that the certified small farms are actually more compliant, right?
Yeah.
But we inspect not as many of them, and in terms of the facilities that we look at really across the board for the medium and large farms, and the medium and large farms have bought a bunch of these to date, right? As of late, as this expansion has happened, because 1,000 to 500 happened really quickly, frankly, in the last couple of years. So there's a lot of infrastructure and a lot of work going on the technical side to address those.
So, but we know that more than half of the milk is coming from the LFOs. They must consume more than half of the land that's in farming if they're producing on the dairy farms. So the above the 50 percentile is being inspected, I would say, on an annual basis. So it's the little guys, the small family farms, they're over a period of 3 years to 7.
And that's just what we don't know. Like, even though our data shows right now that CSFOs are more compliant, right? We call them at least 2 days in advance to say, we want you to be there. We're going to show up for our inspection, right? That's our normal protocol because it's important to have them there. And so, hopefully, like, when I see a cop on the road, I admit I let off the gas pedal a little bit, right? Just even if I'm not speeding, it's just your natural reaction to make sure you're all in check, right? And so, yes, please clean your house, right? When guests come. And so if we show up and we do an inspection and it's compliant, that's great. But that's good. That in our data is going to last until the next time we come back, which is a 7-year cycle. We have no oversight, understanding, because unless we get a complaint, we're not back there in those 7 years, right? So the data, when you look at the large farms, we're there every year, right? And so their need to constantly be on it is much higher, and our ability to find, one small mistake is more, there's more probability, put it that way, right? Because we're there more often.
Now, large farms, you said it, and we know it, are many times the way the quota system's set up. A small farmer will sell to a larger farmer, so the larger farmer wants that quota fix. Now, the next time, so the following year, when you go to inspect the big farm, you must have to inspect the little farm that they added on, right?
Yes. We
So,
inspect it before they get it permitted, and we let A&R know, and A&R often joins us on that. So it gets, before it gets integrated into the permit.
so they're all covered.
Yeah, we usually do a joint inspection.
Yep. Other questions for community members? Brian?
Yeah, so I've been listening. And I think if the ultimate aim is to get the most number of farms in compliance, and this just is my own perhaps political view of the landscape, with the lightest touch possible from the regulatory agencies, and that's the way I kind of view life. In other words, if you can get people to do it because they feel it's the right thing to do, and they don't need to be constantly hammered about it, I think that's better. I happen to think the Ag Agency does a great job, but you and I may not always agree on that, and that's fine.
Sure.
But if the ultimate goal is to get as many people in compliance as we possibly can, to Steve's point, I think he's absolutely right. We need to make sure that there's clarity in the language so that both ends of the spectrum understand what's at stake and how to get there. So I kind of want to maybe shift back to the language. And I don't know, it seems like we were in the top 15 or 20% of other states in terms of the protection that was offered, but I could be way off. I know we looked at some other states, Kentucky, Pennsylvania, whatever.
Michael's on, I don't,
Yeah.
this guy's.
And I think, I appreciate that point. Maybe what would be helpful, could we get what the 30% of the violations actually were? Could we get something, some document, just to show us? That would be really helpful.
Yeah.
Yeah.
I mean, we could dig through it. I'll figure out which format.
Yeah, that would
works
be
for you,
great.
but,
Because if the 30% were in violation, but they were all tiny little things, then yeah, I think that would be helpful to see.
Yeah, I liken it to getting your car or truck inspected.
Mhm.
You know, there's certain things that you sort of have to do. if your tire's bald, if one tire is bald out of the four,
Right,
to me, that's not a, oh my gosh, we
Sure.
really need to.
sure. So let's see what that
Another
30%
tire.
looks like. That'd be great. Yeah,
Sure,
thank
but
you.
isn't this a motive to get the 30% into compliance,
Yeah.
right? Because if they're gonna sit out there and choose not to be compliant, and we're gonna have violations against them, they are then more open and liable to their neighbors doing that.
That was the point I was just gonna make, is aren't they more open and viable? Quite frankly, if there's a disagreement between ANR and the ag agency over whether or not somebody's in violation or not, I think that would open up to lawsuits. If there's a different interpretation of policy in all of that. I don't think necessarily because two branches of government might look at something from a different angle and come at it, that wouldn't. But I think clarity in the law would put us in a position where it would help individuals figure out where they are now. I'm not really in favor of empowering lawyers to beat people down and make a whole lot of money on this.
You are.
No,
Yeah, so just that
Sorry.
30%.
Yeah.
Yeah, yeah. Yeah,
sorry,
that would be-
I'm just not.
I gave that up when I became a public servant.
Hey, Michael, quick question, you weigh in. On our draft bill, where would that fall in the range of right to farm laws, say nationwide? You know, is most strict or least strict or in the middle? Where would it be?
It would be on the less strict side of the spectrum,
Less strict.
meaning less protective of the farm.
Or less protective of the farm.
So
there's, that means more than, they're more strict than what our law would be, or more,
More protective of farming or farms, yes.
So what Senator Collmore portrayed, it's the opposite of what he portrayed.
I didn't quite understand Senator Collmore's statement. We're in the 15 to 20% of,
Yeah, that's true with a lot of things that I say, Michael.
I'm just trying to, that's
No,
not,
no,
no offense.
You're absolutely right, and I had the wrong impression then. I thought, what was the state where you can basically do everything except kill somebody? Is that Oregon?
Oregon.
And I thought we were only a couple steps below that with what's in place now, or maybe with the draft. The rebuttable presumption has those four elements that I think we all, well, maybe not all, most of us can agree. That doesn't provide clarity at all. It provides sort of rabbit holes all the way through the process. And I think it needs to be a little clearer. I don't know that we want to get to Oregon's situation, probably wouldn't have a lot of success on the floor, but maybe we get a little closer. So thank you, Michael, for that, because I was under the impression we were offering farmers a bit more protection than the average state.
No, I would say that all states provide protection of some sort, but
Yeah.
other states are more protective. For example, just Louisiana, Steve made the point earlier that the farmer under Vermont's law needs to show that they're in compliance and that the burden is on the farmer, that they're in compliance with the law. In Louisiana, they have a statement in their statute said that the farmer is presumed to be in compliance with the law. And so the farmer doesn't have to show anything. It's the plaintiff that has to show that the farmer is not in compliance. So that's one way that at least Louisiana and a couple other states are more protective. They shift specifically the burden to the plaintiff instead of the farmer having to prove that they're in compliance.
So I think one of the committee members would like to follow that track and get closer to Oregon, right, Brian?
Let's have a committee vote today.
But You still have the draft of our bill that we changed a little bit, right? Michael?
Yes, yes.
Or could I follow up on Senator Westman's one point about the lawyers?
Sure.
I mean, it's one thing to talk about lawyers, but I think you also have to think to yourself, what about the person that does move next to a farm? I mean, they have to have certain kinds of, I mean, we know they have some rights, but we want to make sure that we're not taking any sort of, in my opinion, power away from them by doing this.
Well, Michael, does our draft give the farmer more protection against the neighbor?
Yes.
That's the goal, right?
Well, can I ask the question? My goal is not to empower the neighbor or to empower the farmer. My goal is that if you're meeting what the set out policy is and what the public goal is, which is statute and policy, I want people to be within those boundaries. And if you're outside of those boundaries, I think legitimately go to court and we work that out. The police in this are more A&R and the ag agency trying to keep people within it. But I'm not trying to empower the person that lives next door or the farmer. I want them all to live within the law. And so that's the place that I want people to be. If I can make the law clearer, so there's not as many suits and you're all following the policy that's laid out, that's where I want people to be. It's not to create conflict between the neighbors and the farmer.
I think then we're all in agreement with that.
So, Michael, what does I keep hearing from talking with one of the other senators is the coming to the nuisance. What does that mean?
So that's the concept that either there's new development next to a farm that wasn't there prior to the farm being in operation, or there's a change in development that occurs prior to or after a farm has been in operation. And then when those people raise an issue of nuisance, the courts usually said, well, you moved to the area next to the operation. You should have known about the conditions there. You don't get to force that operation to change because you moved to that nuisance.
And in our draft, we have 1 year, right? So if as long as the farm's been there for a year, longer than somebody moved into the house.
Correct.
What if we made that, Brian, if we made that 2 years, would you feel like the house person would be more protected?
I don't think I was wondering what the coming to the nuisance is,
Right.
but no, I think the question's more coming, not so much from me, but from judiciary. So I would touch base with them on that. I mean, myself.
So how do you avoid that situation coming to is there a way to fix that or?
I don't know if you can totally eradicate or eliminate the possibility that someone moves in next to a farm and then claims nuisance and then the farm claims coming to the nuisance. I don't think you'll ever totally eradicate. I do think providing a time period during which or right to farm doesn't vest until that time period expires, I do think that that does provide the neighbor or new neighbor some protection.
Well, Brian,
How like or unlike this situation is an airport, when someone moves next to an airport, are there provisions there where people can actually have a nuisance lawsuit against the airport?
Uh, um, it's hard for me to say black or white, yes or no, but I would say in most cases, a court is not going to entertain that nuisance claim unless there's really a substantial change of noise at that airport after the person moved in.
Okay,
Right.
and we have one here in the state, but.
Right.
so what they got sued, right?
I think
Didn't
so.
they bring
Oh, yeah.
a suit against
Sure they
the
did.
guard or something when didn't they have that happen up where you live, Michael?
Yes, there was, I don't know if it actually was filed, but the argument was that the upgrade of the jets by the Air National Guard was a change in the sound, and that the sound study done by the Guard and the FAA was not sufficient. I don't know the resolution of that.
And it's probably a case where there's a federal jurisdictional issues that may preempt anything the state could have done, so.
Oh, that's a good point. Yeah, that's a good point. Yeah,
That is the case, yes.
yeah.
Military's got a little different standing.
Right.
I like the year because it gives you that chance to have one growing cycle. We're not saying 6 months so that they never actually heard, the combine or something. You have that 12-month cycle, right? You move in any time of the year, you get to see the whole
the
growing
whole
season,
year.
right? And so I think a year minimum. I don't know why you need to go to 2 years or 5 years or whatever, but
Well,
I'd be
the
glad to hear it.
problem, well, I don't know if it's a problem because I don't think it is yet, but people are buying property up here without even seeing.
Right.
Well, if the realtor doesn't, or if they don't ask, well, who are my neighbors gonna be? What do my neighbors do? I mean,
Well, what do we owe a buyer? Do we owe a buyer 5 years worth of like finally showing up from New Jersey? I came from New Jersey, right? Do we owe someone a really long runway to finally get here? I don't know. I think a year's reasonable. I don't
think
know.
so.
I don't know.
think
I want to
a
know what
year-
people think.
A year is enough, but I don't want Brian to have to. look.
No, I mean, I don't know the answer to that question. I think it's judiciary that last year, I guess. So what I'm also trying to understand, the House never passed this, I guess, last year.
No, they passed it over to us.
Well, that's right, it came from the house.
Came from the house.
It's an S bill. Was it an S bill last year, wasn't it?
No, I think it was an H bill.
I don't always figure that out.
Yeah,
Well,
maybe, anyhow, the short of it is, I think it's that question I would run by judiciary, because that's where it stopped last year, coming to the nuisance.
We can figure out what the
Yeah,
issue
yeah.
is.
Well, so we've streamlined the draft to some extent from from the original. But we'll keep working on it. And so you think the RAPs are for farms in compliance? That covers pretty much everything.
That, the base of our rules, the MFO and LFO do point to the RAPs, right?
Right.
And the MFO and LFO and RAPs all say you can't have a discharge.
Yeah.
Right, so if there is a discharge, again, it goes over to A&R and they make a determination. They can enforce on their own if there is a discharge from their perspective, and they can tell a farm they need to get a CAFO permit if they felt that the discharge was ongoing and it was something that needed to get a permit. So those are all the regulations, and RAPs are the base. Almost all of them point to the RAPs.
Now, where do flies fit in?
Wise?
Flies.
Flies, oh, I was like, why, it's right before D.
Like I say that in French.
No, you said it right.
Yeah, you know, there was a little accent there.
There was a case years ago, it was before my time.
The chicken farm, but farm,
And they were, my understanding of that was, so that was under large farm, and large farm has still odor, noise, flies, traffic, and other pests as regulatory authority that we have to implement. And my understanding of that whole situation is our entomologist did go up there and assess the situation. It was a poultry operation next door to a dairy operation. And they're both fairly good size. I believe at the time they were probably a medium size and a dairy and a large size poultry. And I'm not very good at baseball, but probably someone could hit a ball that far from one to the other, right? They weren't very far from each other.
No.
And so the entomologist went up and studied in the dairy barn and found that the LFO standard is any of these nuisance things, if they are comparable to a similar farm of a similar type, then it's not a nuisance. But if it's above that, then it would be. And so the volume of flies that were in the dairy barn were excessively above what is normal in a dairy barn of that similar type and similar size. And so the agency made the determination that there was something going on there, and we worked with the farm to try and deal with lowering the fly population through several means, management, and then also applications to reduce them. So
yeah, we had a visitation to that egg farm, chicken farm, and it was set up maybe a week ahead. And in that week, by the time we got there, nobody, and I mean nobody, could find the form at the chicken farm. There wasn't one to be had.
So we saying that the ag committee should do the inspections?
there you go.
No,
Absolutely.
I remember that day, everybody, well, where are all those flies? Because they had pictures of the
Tons of them.
green door.
I remember something like that.
Yeah, it was,
Hey, Mike, did the House pass this bill has the House passed this bill? Can you just clarify?
So a bill was introduced. It was sent to judiciary. It passed out of House Ag, went to judiciary. Judiciary did not pass it out. What
Okay.
happened, that there was an agreement on a revision to change the scope of activities that were protected under the current right to farm. And that was included in one of the miscellaneous ag bills. And that did pass. But changing the standard
Right, did not pass.
did not pass and was not
Thank
sent to the Senate.
so it was a Senate bill then. So the House didn't ever work on that.
There were two bills. There was a House bill, there was a Senate bill. But what ultimately passed started in the House.
Any other questions? Thank you.
Thank you both.
folks, For.
Yeah,
Thank you.
thanks a lot.
Appreciate it.
Yeah.
Thanks so much for having us.
Thank you
Yeah,
both.
Thank you. Thanks for working on this issue. Happy to do whatever we can to help.
Well, we just like to get it up to where, it should be for this day and age, because it's very overwhelming. And,
Well, and it's pretty clear farms are changing, right? And that's one thing that the current doesn't, if there's a change in the type of agricultural activities, and, we've seen it, whether it's in dairy itself, but also, there's so many new, like accessory on-farm business and other
Hemp, yeah.
activities that people are doing to diversify their farms. And so
Yeah.
their actual type of farming is changing.
yeah, I could see where if you were on a back road and you put in an alternative business where you increase the traffic, neighbors would holler about that because, cars at least every hour now. We used to see one a day. Well, anyways.
Thank you.
Thank you.
And we'll
Thank you.
keep
The
plugging along.
inspection cycle, if I don't get it in my head, small firms are not inspected.
7 years.